Hi everyone, my name's Emma Long and today we're going to be talking about the US Supreme Court. More specifically, we're going to talk about the Supreme Court and the issue of abortion and try to understand why, in a case called Dobbs versus Jackson Women's Health on the 24th of June 2022, the court withdrew constitutional protection for abortion access in the US. Dobbs involved a Mississippi law which banned abortion access after the 15th week of pregnancy with very limited exceptions. This law deliberately violated earlier Supreme Court rulings, more on those in a moment, which established that states could not substantially restrict abortion access until after the point at which the fetus can live separately from the parent, known as fetal viability, and currently placed at around 24 weeks of pregnancy. The aim of those who passed this law was to press the Supreme Court to accept the case and then to argue that the justices should overturn earlier rulings. This is what the court did, the majority arguing, as you can see on the slide, that under the Constitution, abortion access was a question for the states and not the courts to decide. It's very rare for the Supreme Court to overturn its earlier opinions when it interprets the Constitution. Estimates suggest that it has happened in less than 1% of cases in the court's history. It is also almost unprecedented that the court should remove constitutional protection from a right previously recognised and say it's no longer protected. So how did we get to a point where the court could make such an unusual decision? Let's start with the case that was overturned in Dobbs, Roe versus Wade from 1973. Although it's often said that Roe granted women the right to an abortion, it actually did not. Justice Harry Blackmun's majority opinion sought to balance the right of a woman to make choices about her pregnancy with the accepted state interest in protecting the life and health of its citizens. In the first trimester, when mortality rates for pregnancy and abortion were similar, the state had few reasons to interfere in a woman's choice to terminate a pregnancy, the court argued. In the second semester, the state interests increased and laws regulating but not banning abortion might be acceptable. And in the third trimester, after the point of fetal viability, states could impose even stricter restrictions. This was not an outright grant of a right to choose abortion, which is important for understanding the political debate which followed. Abortion did not become a political issue because of Roe. Questions of reproductive choice were a big part of the women's rights movement that emerged in the US from the late 1960s. But the debate about abortion was largely at the state level. In the late 1960s and early 1970s, states including California and New York made access to abortion easier, others didn't. There was debate and disagreement, although nowhere near the level of what we see today. And about 30 states still restricted abortion access in 1973. One of those states was Texas, which had an exception only to save the life of the mother when Norma McCorvey, pregnant with her third child, claimed that she had been made pregnant as a result of rape. Now, later in life, she admitted that she had not been raped, but thought that the claim might help her case. Pro-choice lawyers Sarah Weddington and Linda Coffey saw a chance to challenge the Texas law using McCorvey's case, although in arguments she was known as Jane Roe to preserve her anonymity. In Roe, the Supreme Court not only struck down the Texas law, but all similar laws across the country. They created a national solution to what had, to that point, been state-level debates. Because a constitutional decision by the court can only be overturned by the court itself or by a constitutional amendment, once the court decided Roe, it effectively stopped all state-level discussions about abortion, prevented debates about how the issue might be approached, and having polarised debate left few options for either supporters or opponents of abortion rights to work out compromises. Even supporters of abortion access, including former Justice Ruth Bader Ginsburg, have argued that the court's all-or-nothing approach may have done more harm than good to the broader cause. The initial reaction against Roe came mostly from American Catholics. As the 1970s developed, conservative white Protestants also joined them in opposing Roe. They initially sought a constitutional amendment to overturn the ruling, but this was never likely, and their strategy changed. One tactic was to get more conservative judges on the courts, especially the Supreme Court, and try to convince them to overturn Roe. This fit with the aim of many Republicans during the presidency of Ronald Reagan in the 1980s, who wanted more conservatives on the nation's courts to challenge, restrict, and overturn some of the key decisions of the Warren Court era, the period from the late 1950s and early 1960s, when the court massively expanded protections for individual rights against the power of the state, often referred to as the rights revolution. Thus, the interests of religious and secular conservatives coincided, and opposition to abortion became a potent mix of religious, moral, and political arguments that became part of what we now refer to as the culture wars. In 1992, a case called Planned Parenthood versus Casey, anti-abortion campaigners thought they finally had a good chance to overturn Roe. Presidents Nixon and Reagan had made a number of key appointments to the court, and now there appeared to be a conservative majority which anti-abortion campaigners hoped would support their views. They were disappointed, but Casey is nevertheless a hugely important case. Casey arose out of campaigners' successes in getting state legislation to control and restrict abortion, a tactic they used as well as targeting the courts. The result that most focus on is that the court explicitly refused to overturn Roe, making it appear as a success for the pro-choice movement. However, equally important and less emphasised is that the justices also rewrote key parts of Roe. In Casey, the court argued that laws which placed an undue burden on a woman's access to abortion were unconstitutional. But what exactly was an undue burden as opposed to one that was acceptable? The court opinion was not at all clear, and it laid the foundation for Dobbs. Crucially, Casey allowed states to pass laws severely restricting abortion access so long as it was not banned outright. So-called trap laws, or targeted regulation of abortion providers, became popular. Written in the language of protecting a pregnant person's health, they primarily aimed to close abortion clinics. Other laws, so-called heartbeat bills, banning abortion after a fetal heartbeat could be detected, and personhood laws, holding that life begins at conception, embodied the religious underpinnings of much anti-abortion activity. This, along with recognition in Roe and Casey that states had an interest in protecting potential life, were reflected in one of the key arguments in Dobbs. So successful were these laws that even before summer 2022, Roe was not a right all pregnant people could access. In Texas, for example, women often had to drive more than 300 miles to access such provisions, making it all but impossible for the poor, the disabled, those unable to take time off work, or those without transportation. So, Casey opened the door for political anti-abortion activists to push for laws which imposed greater restrictions on abortion and which weakened Roe. The court in Dobbs made that formal and explicit and pushed things further than before, but it didn't come out of nowhere. Decades of legal and political campaigns had already undermined Roe, even if it wasn't entirely clear until the 24th of June 2022. There are 2 in-class activities linked to this lecture, both of which appear in the slides which follow this. I hope you enjoy discussing the issues involved in this topic. Thank you.